Thank you, Zena. Greetings from our nation's capital. Good afternoon, and thank you for joining OHRP for this third installment in our Common Rule Basics webinar series. Today's webinar is titled, How Do I Review the Let Me Count the Ways, the Types and Manners of IRB Review. A quick disclaimer before we begin, any opinions expressed in the course of this presentation are my own and do not necessarily reflect the policy of the Department of Health and Human Services or the Office for Human Research Protections. Any references to the regulatory provisions in the Common Rule in this presentation have been simplified to facilitate understanding. Please always refer to the actual text of the Common Rule, which is available on the OHRP website for a complete and accurate description of the regulatory requirements. Here are the learning objectives for this basic level presentation today. First, we'll introduce expedited and convened IRB review. Then we'll talk about some of the review requirements for common lifecycle actions. Then we'll finish up with a discussion on limited IRB review. Again, this is a basic level presentation, which means that we'll try to focus on big picture ideas and some details. We don't have enough time to talk in depth about each topic. In fact, many of the items we'll be discussing today could be their own webinar. The Common Rule establishes regulatory requirements for non-exempt human subjects research that is conducted or supported by a Common Rule agency. Please note that funding is a type of support. So you can say something like, since this research is funded by the NIH, the Common Rule applies. But please be aware that grant money changing hands is not the only activity that brings research under the purview of the regulations. If the research is conducted by a Common Rule agency, say the Department of Defense, then these regulations apply even if no money changes hands. If you joined us last week, then you know we discussed how the Common Rule does a great job of providing the requirements for IRB approval, but does not specifically tell institutions how to implement these requirements. When the regulations are silent, institutions are given the flexibility to fill in what is missing. For instance, the Common Rule tells us that non-exempt human subjects research that does not qualify for expedited review must be reviewed at a convened meeting of the IRB. But how this meeting is set up, whether it's in person or online, the order of the agenda items, if anyone other than the IRB members are allowed to attend, that's all at the discretion of the institution. And so long as what they decide is in line with the regulatory requirements, they're allowed to do it. We'll discuss some of this a little bit later. The Common Rule tells us that each institution must have written policies in place for how it will review and approve the following common lifecycle actions. And we'll talk about these each individually later, so you can view this as a bit of a roadmap for the presentation. Initial reviews. Non-exempt human subjects research must be reviewed and approved by the IRB prior to that study beginning, before the study commences. And this first review is called initial review. Conducting a continuing review. So this is a review that occurs at least once a year. I say at least because a study can be reviewed more than once a year at an IRB's discretion. An IRB might require this perhaps for a very risky intervention or if there's a particularly vulnerable population. There must be policies in place for how IRBs will review amendments, which are changes to already approved protocols. These changes cannot be implemented until they are approved by the IRB, except in certain instances to avoid immediate harm to participants. And of course, even then, those changes have to be submitted to the IRB after the fact. The IRB must also have policies to ensure prompt reporting to the IRB and other authorities for incidents of unanticipated problems, serious or continuing noncompliance, and suspension or termination of IRB approval. Now, we won't be discussing these things today, but just so you know, there are requirements found in the Common Rule. So all these procedures that institutions have to have, they should be made known to those working in the IRB office, IRB members, and investigators. And this way, everyone carrying out their duties can carry out their duties in a consistent and effective manner. And just a point of clarification, these policies can be reduced to paper, have a physical paper copy, but they don't have to be. And it's probably more likely that these policies are going to be made available on the internet or intranet, but it's totally up to the institution to decide what they want to do. And with that in mind, institutions are likely to have different policies in place just because they might differ in size, the number of studies they have, the type of funding they receive, as well as the type of research that they review. Research that is minimal risk and fits within a designated expedited review category can proceed through expedited review. All other non-exempt research must proceed through a convened or a full board review. The regulations tell us that the IRB chairperson can perform expedited review, or he or she can identify other IRB members who are qualified to perform this review and delegate that duty to them. Expedited review can happen whenever the individual finds time to review it. The regulations don't provide any details on when that has to be done. The convened review, however, has to occur at a meeting, and the meeting has to be attended by the majority of the full board and the non-scientist, and that's what's known as quorum. So at the meeting, you have to have quorum present to have a vote, and voting is only permitted in real time. You're not allowed to vote ahead of time or send in a vote or vote after the fact. So you have to be in attendance at the meeting. And then lastly, the regulations used for both expedited and convened review are the same. So for expedited review, you have one person that's applying all of the same review criteria that's used in a full board meeting. And so this means the 111 review and approval criteria, as well as the 116 informed consent criteria. Those same set of standards are being applied individually by an expedited reviewer and then collectively as a group in the full board review. So expedited review does not mean that the reviewer is cutting corners or leaving things out, okay? The regulations say that research must proceed through a convened board unless it can be reviewed through expedited procedures. Well, there are two requirements for having an initial expedited review. The first is that the research presents no more than minimal risk to participants. And please note that we have to have both prongs satisfied because we have that and there. And the research fits into one of the 9 expedited review categories. So for initial review, it will be 1 through 7, and we'll talk about later categories 8 and 9. So this means that just because something is minimal risk, it does not automatically qualify for expedited review because of this second prong that you have to fit into expedited review category. And a minimal risk protocol that doesn't fit into a review category will require full board review. So for these reasons, please be careful when using the terms minimal risk and expedited review because they're really not interchangeable. Expedited review can also be used for minor changes to already approved research. This could be research that was initially reviewed by the convened board, and we'll talk about amendments in a little bit. And lastly, expedited review can be used for a limited IRB review, which you know from our objectives we'll be talking about later in this workshop. A quick note, OHRP recommends that expedited review procedures not be used for research involving prisoners. However, if an IRB chooses to use expedited review for research involving prisoners, OHRP, of course, recommends that the prison representative of the IRB be one of those designated reviewers looking over the research. Looking to minimal risk, the regulations actually provide us with a definition. It's the probability and magnitude of harm or discomfort anticipated in the research are not greater in and of themselves than those ordinarily encountered in daily life or during the performance of routine physical or psychological examinations or tests. So risk exists in two vectors. The first is the chance of it occurring, which is the likelihood or the probability of the event happening. And the second is how harmful it will be, which is the severity or the magnitude. So you want to compare this to everyday life, the risks that you experience walking down the street, for instance, and those that you'd find in a doctor's office with a regular physical or psychological exam. These are somewhat objective elements that an IRB can point to when making a risk determination, even though there is inherently some subjectivity in the definitions. The second prong for research to be reviewed through expedited review is that falls within one of these 9 categories from our 1998 list. As I mentioned earlier, the first 7 are for initial and continuing review, while 8 and 9 are only for continuing review. Now, please don't be upset with me, but unfortunately, I don't have any information on when this list is going to be updated. And also, please don't be overwhelmed by the information on this slide. It's just a brief summary of the categories. I do want to point out, just because that activity is listed here does not automatically mean that it's no more than minimal risk. Again, we're looking for there to be a minimal risk designation, and then we're looking for the research activities to fit into one of these categories on the list. Worded differently, an activity's presence on the list merely means that the activity is eligible to be reviewed through expedited review, but only when we have the proper circumstances. And that would be research that's no greater than minimal risk to the research participants. There is an additional caveat that the expedited review procedure may not be used where identification of the subjects and or their responses would reasonably place them at risk of criminal or civil liability or damaging to the subject. So think of things like their financial standing or employability. You can proceed if there are reasonable and appropriate protections implemented so that these risks related to invasion of privacy and breach of confidentiality are no greater than minimal risk. So an IRB reviewer, when looking over an action, can approve it. The reviewer can request changes in order for approval. And when this happens, the researcher will update the documentation accordingly and then resubmit for the reviewer to confirm that all of the criteria are met. The reviewer can also refer an action to the full board for its review. Now, why might a reviewer do this? Well, maybe because he or she believes that the risk level is greater than minimal risk, and thus it's not eligible for expedited review. Now, an expedited reviewer is not allowed to disapprove research. Only the full board may disapprove research. Each IRB has to have a mechanism for letting the rest of the members know what actions were approved through expedited review. This could be as simple as a weekly email summary or a list of the approved items attached to a meeting agenda. Each institution has the flexibility to implement this as they see fit. When actions are approved, the approval should include the risk classification and how is eligible to proceed through expedited review. For instance, the research is minimal risk and it meets the requirements outlined in Category 5, research involving materials that have been collected or will be collected solely for non-research purposes. Now, an IRB member is the one determining if research is no more than minimal risk, as well as which of the categories applies. Category 5 applies to research involving previously collected materials, including those materials that were collected for research, so long as they were not collected for the current research purpose that we're talking about now. And it also includes materials that will be collected solely for non-research purposes. So you have materials collected in the past and then a future prospective collection. So please be careful if there's a study that uses materials from a source that has ongoing collection. Only the samples that were collected prior to the approval of that study can be used. That is, if the study has begun and new materials are being added and collected, then that'd be considered a prospective collection and it wouldn't qualify for expedited Category 5. Category 7 is typically used for surveys, interviews, and focus groups. This category can be used for research that might otherwise be exempt in categories 2 or 3, but for one criteria. So I'll give you an example. Exempt category 2 has prohibitions on when children can be research participants. It's limited to the involvement of educational tests and observation of public behavior. Exemption 3 is for benign behavioral interventions, but research involving children can never proceed through expedited Category 3 or exempt Category 3, apologies. So expedited Category 7 can be used for research with children that might be survey research that wouldn't fall into exempt Category 2 or Category 3. As I just alluded to, the common rule says that any non-exempt human subjects research, except that which may proceed through expedited review, must be reviewed by the convened meeting of the IRB, and this is called full board review. This research is typically interpreted as greater than minimal risk, right? That's what people tend to think of. And a classic example of this is a phase 1 clinical trial for a new drug. But I want to point out, and we'll cover this shortly, that minimal risk research can be reviewed by the full board and in some instances has to be. And also, just because something can be reviewed through expedited review doesn't mean that it has to be. The regulations are considered a floor, meaning that an institution can always add other requirements, some of which might be more protections or safeguards for human research participants that extend beyond the regulations. So it's a wrong assumption that just because something is reviewed by the convened IRB, that it's automatically greater than minimal risk. So because a lot of this content was given last week, and I'm trying not to be repetitive, I'm going to briefly touch on some aspects of IRB membership and the IRB meeting that were otherwise covered last Tuesday. When people hear of IRB review, the convened meeting is usually what they think of. And the meeting takes place in person or virtually. And the IRB members, who should be diverse in their backgrounds, demographics, and subject matter expertise, discuss individual research actions one at a time. The members should have reviewed the documentation for each item before the meeting and be prepared to talk about why something does or does not meet the regulatory requirements. And these regulatory requirements, as we talked about earlier, are the 111 approval criteria and the 116 informed consent criteria, as well as anything else from subpart A or any of the other subparts if certain vulnerable populations are involved. The IRB also reviews the research according to institutional policies. So members need to be knowledgeable not only in the type of research that's being reviewed, but how to apply regulations and institutional policies. The meeting is the opportunity to discuss not only the regulations, but any and all ethical issues that are surrounding the research. An IRB must have a minimum of 5 members with at least one scientist, one non-scientist, and one unaffiliated member. It's possible for one person to occupy both a non-scientist and an unaffiliated role. So in order for this meeting to occur, you have to have quorum, which is a majority of the primary voting members, plus the non-scientist. In a case of a 5-member IRB, 3 members, one of whom is the non-scientist, must be present. If at any time a majority of the primary voting members is lost or the non-scientist is not present, there is not quorum and the board is not allowed to vote on any items. Now the IRB can vote to approve research, require changes for approval, disapprove, or table the research before them. Approval only occurs when a majority of those primary voting members who are present at the meeting vote for or yes for the action item. The IRB minutes for the meeting should reflect each item discussed, the major points, especially those that need to be resolved, and how each member of the IRB voted, as well as the outcome. So here's where you have some more flexibilities for institutions, as each is able to develop their own individual specific policies. These should cover things like if there's a reviewer system. A large IRB that reviews a lot of research might implement a primary and secondary reviewer system. This is where 2 individuals conduct thorough, in-depth reviews and lead the discussion of the research items. So let's say an IRB is reviewing a new drug study that involves children. The lead reviewer might be a pediatrician whose knowledge and expertise might go beyond the understanding of a regular member on the IRB. The pediatrician would be able to describe the current standard of care and how the new drug compares to that. The secondary reviewer might also be a physician capable of understanding the signs, but not having the same subject matter expertise as the primary reviewer. Now, this type of system does not relieve the rest of the board from having to review the study. It just helps those with the necessary expertise share their knowledge with the rest of the board. The IRB has to have a way for investigators to submit their research packets, as well as for the IRB members to review them ahead of the meeting. The majority of IRBs have electronic systems in place. And again, this is going to vary from institution to institution, and that's okay. An alternate member is an individual who closely mirrors a primary member in experience, background, role, and can vote in place of that person, that specific person, in the event of an absence, which would be, say, for instance, a conflict of interest. So an IRB should have policies in place to govern alternates, their use, and just conflicts of interest. This was, believe it or not, a quick review to a very complicated topic. And last week's webinar will be posted to our website shortly. So if you're interested in learning more about membership requirements, quorum, and voting, at the end, I'll be able to direct you to some mini tutorials. All right, so what are some of the common research actions that the full board or expedited reviewer is going to be examining? Excuse me. Well, the first event, if you will, in the life of a research protocol is its initial review. Before a research study can commence, the regulations require that it be reviewed and approved by the IRB. The IRB is looking at the research packet submitted by the researcher. So this is going to have the protocol, the informed consent, data collection forms, advertisements, etc., things of this nature. If you joined us 2 weeks ago, you have seen Mariana's great presentation outlining the IRB approval requirements found in 45 CFR 46111. And that will also be available shortly on our website for you to view. These criteria include things like making sure that the risk to subjects is minimized and that selection of subjects is equitable, just to name two of them. The IRB must ensure that all of the informed consent requirements found in 45 CFR 46.116 are applied, and these consist of the basic and additional elements. The revised common rule added that a key information section should appear near the start of the informed consent document. This is a concise and focused presentation of what a reasonable person would want to know in order to make informed decision about whether or not to participate in the study. The 116 criteria for informed consent can be waived or altered under certain conditions, and this is true for the documentation of consent as well. The regulations require that the IRB have a way to notify investigators and officials of its decisions. If you have an electronic submission system, being able to send out messages is likely a feature of that, though standard email also works to accomplish this purpose. The 111 and the 116 criteria apply whether it's full, board, or expedited review. I'm saying it again. But also be aware that there are likely other institutional requirements that apply, and there could be requirements from other federal agencies. For example, you might have HIPAA, which is from the Office of Civil Rights, or you might have regulations from the FDA. Funding agencies they might also have additional requirements for you to be aware of, whether it's coming from the NIH or the Department of Defense, which has the Department of Defense instruction, the DoD. And this is just an example of something that's additional that would govern. This is just a real quick snapshot of the initial review. The 2018 revised common rule only requires annual review or continual review of studies that are initially reviewed by the convened board, or I should say that are reviewed by the convened board. The review must happen no less than once a year. So how is this date determined? We'll look at the initial approval date and add a year. If an IRB initially approved a study today, July 25th, 2023, then the first continuing review would have to occur by July 25th, 2024. But it's kind of rare for a study to be approved at the meeting as is, right? So when a study is approved with changes at the meeting, the IRB has flexibility in how it wants to determine the initial expiration date. It might opt to have the initial expiration date be the meeting date, or did the date that the IRB reviewer reviewed and approved the changes. So let me give you an example. Let's say that the research is approved requiring modifications on July 1st, 2023. And then the reviewer signs off on the changes today, July 25th, 2023. The IRB should have a policy for determining if the initial expiration date will be July 1st or July 25th, 2024. Either would be acceptable. When a study is not reviewed and approved within a year, the approval lapses and the research has to stop instantly. Now, there is an exception that it can continue if stopping would harm the participants. So think of a therapeutic trial when withholding a study drug might have negative consequences on the health or safety of the participants. An IRB might require the studies reviewed more frequently than once a year, and it's in their purview to do so. But if they decide that, this reason has to be documented. I also want to clarify that continuing research during a lapse of approval can be considered serious noncompliance. So you really want to make sure that if approval lapses, everybody stops unless it's necessary for the safety of the participants. When the IRB receives the continuing review package, which will be the protocol, the informed consent, likely a report of what's happened since the last review, it can start from a presumption that the previously reviewed materials continue to meet the approval criteria. So that is, there's no need to review the unchanged material to make sure that it still meets the 111 and the 116 requirements. The IRB is looking to make sure that the information provided is consistent with the previously approved protocol. So if there are any discrepancies, you can ask the researchers to resolve those. So this enables the IRB to then focus on new information provided by the researcher or otherwise that would alter any of the IRB's prior determinations. When conducting the review, OHRP recommends that the reviewers pay special attention to 4 areas. The first is risk assessment and monitoring. Again, looking to any of the new information learned. Are the risks to subjects minimized? Are the risks to subjects reasonable in relation to any anticipated benefits, if any, to the subjects, and the importance of the knowledge that may reasonably be expected to result? Look at the information received from the date of the last IRB review and approval. This could be from the data safety and monitoring reports. The IRB, if they previously required that changes be made, whether through an amendment or to enhance the protection of the participants, this is an opportunity to make sure that those changes have been implemented and that they are having the intended effect of protecting the subjects. The IRB should receive the most up-to-date version of the consent form. So here it's important to have good version tracking, and that can be obtained by using approval dates, stamps, expiration dates on the consent form, things of this nature. The IRB is looking for the informed consent document to provide an accurate and up-to-date description of the reasonably foreseeable risks and discomforts of the research to the subjects. This is also a time to look at how consent is obtained. Additionally, the IRB can make a determination that if there are any new significant findings that might affect participants' involvement in the study, if now's the time to share that information or those findings with the participants. The IRB can look at the researcher's credentials and time commitments. Look for a suspension or loss of licensures and also if the researcher has had an increase in research studies while maintaining all other time commitments. This would imply that he has less time for each study. Any complaints filed against the researcher should also be examined. The IRB can look at the institution where the research is being conducted and see if the facilities and if the financial commitments are still adequate to support the research. The IRB should look at the number of participants who have enrolled. Is the study on track to hit the planned number of enrollees? Well, if not, what's the problem? Can it be fixed? The number of subject withdrawals and the reason for the withdrawal should be looked at too. If participants are withdrawing because of a high number of serious adverse events, then procedures for risk minimization and the risk-benefit analysis should be revisited to make sure that the study can continue. There are several options available for the IRB to use expedited review process for the evaluation of a continuing review. Now, we talked about the 9 categories for expedited review. Well, Category 8 specifically mentions continuing review of research previously approved by the convened board. There are 3 scenarios in which continuing review for these studies can proceed through expedited review. The first has 3 components that must be met. 1, enrollment is closed, meaning that no one new is joining the study. 2, that all research-related interventions are complete. And 3, that the remaining participant involvement consists of long-term follow-up. So these activities might be things like answering questions through a survey on the phone and having physical examinations, perhaps. The institution has some leeway in deciding what counts. The second 8B is that no one has enrolled in the study since its initial approval, and no new risks have been identified in the study. So how can new risks be identified if no one's been enrolled? Well, if it's a drug trial, these could be found possibly in an updated investigator's brochure or package insert. A convened board can determine at the time of initial review that a study poses minimal risk and fits into an expedited category. And then finally, if The only study activities left are data analysis. It can proceed through expedited review. This means that participant involvement is entirely complete and that there won't be any other new participants. So category 9 allows for research that's initially reviewed at the convened meeting to have an expedited continuing review if the research is not conducted under an investigational new drug application or an investigational device exemption. So categories 2 through 8 do not apply, but the IRB has determined and documented at a convened meeting that the research involves no greater than minimal risk and no additional risks have been identified. So here's a case example for us to look at. A research study is approved at a convened meeting as greater than minimal risk and requires continuing review as specified by the regulations. At the time of the study's first continuing review, under which of the following circumstances can the continuing review proceed through expedited review instead of having to go through the full board? So here are the answer choices. Take a minute and please select all that apply. It looks like most of you have responded, but I'll give a little more time. Okay, they're starting to trickle in. So I'm getting ready to stop. Last chance and stop. And yes, the majority of you got this right. It's the second and third options here. So in this fact pattern, we know that we have a previously approved study by the convened board, and it can proceed through expedited review in category 8 in 3 scenarios. And so right off the bat, this makes the first answer choice incorrect because continuing review cannot always be expedited. It has to fit within one of these categories. The first, 8A, is that enrollment is complete, as are all research-related interventions, and that only long-term follow-up exists. We don't seem to have that in the fact pattern, right? That's not something that's here. Now, the second is 8B, and that states that no one has enrolled yet and no new risks have been identified. And you'll see we do have that as an answer choice here. And then 8C is that the only study activities that remain are data analysis. And I was hoping that you would see if participant involvement is complete and that the study team is only writing manuscripts. They're either only conducting data analysis or possibly they've even finished their data analysis. A point being that the study can proceed through this third manner, 8C. As mentioned earlier, the common rule requires that an IRB has a policy for changes to previously approved research. These proposed changes are commonly referred to as amendments. Why might the research need to be changed? Well, there's quite a variety of reasons. The procedures might be inadequate to collect the data points necessary to add the objectives, so more tests are added. There might be issues with enrollment due to overly strict inclusion or exclusion criteria, so they're relaxed perhaps by raising the age range or expanding the age range for participants. Whatever the changes to the protocol, the common rule has some requirements when we're talking about amendments. So institutions might have a policy to describe what sorts of changes are considered to be minor and thus can proceed through expedited review. An example could be a change that isn't participant related and doesn't affect any objectives, like using a different laboratory assay to analyze a blood sample. The value in detailing what changes or what types of changes are minor is that it reduces administrative burden for the full board. A study that initially proceeds through the convened board can have an amendment go through expedited review if the changes are considered minor. Institutions will likely vary on what is considered to be minor, but OHRP has always considered minor changes to be changes that will not likely put the participant at a risk higher than before the change. When changes do affect participants, it might require revising the consent form and possibly reconsenting participants. This would be the case if participants are on study and the risks of the study change. Each IRB needs to have a policy to govern these circumstances. Do consider the value add and the protections offered to participants. For example, if participant involvement in an observational study has been complete for over a year and an investigator changes his phone number, changing the phone number in the consent form and then redistributing it to all the participants might not be necessary. By now, you've noticed that the common rule is very big on letting people know things. So the IRB has to have a plan for disseminating IRB decisions to investigators and institutional officials. The IRB must approve changes to research before they are implemented, except when necessary to eliminate apparent imminent hazards to participants. When these unapproved changes occur, the IRB has to have a procedure in place for the researcher to notify the IRB after the fact, promptly and without delay. All right, now let's turn to limited IRB review. So what is limited IRB review? Well, it's a specialized type of review that examines several very specific characteristics as defined by regulations that are present for some exemption categories. Since this is for exempt research, the common rule regulatory requirements for 111 IRB approval and 116 informed consent do not apply. Okay, the review is limited to the specific provisions which we'll discuss on the following slides. Limited IRB review is typically conducted through expedited review, meaning that one person reviews the research, not the full board. So which exemption categories require limited IRB review? Limited IRB review is required in the last prong for exemptions categories 2 and 3, and for broad consent exemptions of categories 7 and 8. And those are for secondary research. We're going to discuss these briefly. Remember, limited IRB review is for exempt research. So I just want to reiterate, the non-exempt requirements do not apply. So just a couple more things to be aware of. There is no requirement for continuing review of exempt research. You do not have to post a consent form for exempt research, and you do not need to report incidents for exempt research. Your institution might have a policy, but that's not found within the common rule. Exemption category 2 deals with educational tests, surveys, interviews, and observation of public behaviors. And category 3 covers benign behavioral interventions. Each of these exemptions have different stems in the regulations, but then they have the same 3 prongs that have to be satisfied in order to be considered exempt. And only one of those 3 has to be satisfied to be considered exempt. So the last prong for each of them reads, the information obtained is recorded by the investigator in such a manner that the identity of the human subjects can be readily ascertained directly or through identifiers linked to the subjects. And an IRB conducts a limited IRB review to make the determination required by 46111A7. And so what does that say? What does 46111A7 say? Well, when appropriate, there are adequate provisions to protect the privacy of subjects and to maintain the confidentiality of the data. Please remember that the regulations require that an IRB is sufficiently qualified to adequately evaluate the studies it reviews. And now that's a requirement found in 107A. So in this context, this means that an IRB must be sufficiently qualified to make the determinations of privacy protections as well as the confidentiality protections involved. So a reviewer must have the proper expertise to do this. So this means that you might have to periodically train your IRB members in privacy and confidentiality procedures. And one way to do this is that you could invite experts with these expertise to come give trainings or even to consult with your IRB. Exemption 7 requires broad consent, and this is again for secondary research. So said differently, this category cannot be used for primary research. Category 7 is for storage and maintenance of identifiable materials for unspecified secondary research with broad consent. A limited IRB review is conducted to examine privacy and confidentiality protections, as well as to look at some aspects of broad consent. That broad consent was properly obtained, and that the consent is documented, or that the documentation is waived accordingly. Subjects providing broad consent should have a reasonable expectation for how their identifiable private information and identifiable biospecimens could be used in secondary research. If a broad consent includes limitations on the type of future research, those limitations must be honored. So if there's a reason to believe subjects might be particularly concerned about a type of secondary research that's being proposed for exemption, the IRB that's conducting the limited IRB review, this individual, should consider whether a potential subject would expect that their broad consent would cover such research. So the reviewer needs to take into consideration what the subjects kind of thought they were considering too, right? If something is laid out as this will not happen, then you can't do research on that later. Category 8 is for secondary research use of stored identifiable materials with broad consent. And this also requires that a reviewer look for the privacy and confidentiality protections. It also adds, when compared to 7, then the investigator will not return research results unless required by law. And we also have the requirements for documentation or documentation of waiver of consent has occurred. Much like category 7, there's the same requirement that subjects providing broad consent should have a reasonable expectation for how their identifiable private information and identifiable private biospecimens could be used in secondary research. So the reviewer needs to take this again into consideration. Let's look at an example. So Steve is an IRB administrator, but not an IRB member. The chair has asked him to make exempt determinations. Which of the following can Steve do? So please select the best answer. I will give you some time. And a lot of the responses have come in. There's some stragglers, I think. So let's hurry it up. All right, I'm gonna call it, and there you go. The second answer choice. And good. Most of you got this right here. So Steve can make exempt determinations, but not conduct IRB review. The regulations do not say who can conduct exempt determinations. So an IRB administrator is permitted to do so. Your institution will have a policy. There's no regulatory requirements that an IRB member do this. So Steve is qualified to make the determinations, but can he do a limited IRB review? No. So that task is limited to IRB members only. And that's the same for expedited review, right? You have to be an IRB member, and that has to be designated to you by the IRB chairperson. So the correct answer here is the second one. I do want to point out our draft limited IRB guidance is available on the HRP website, and we are currently receiving public comments on it through August 15th. So please be sure to take a look if you'd like to learn more about limited IRB review and want to get a take on our current thinking. And please do comment. Those are extremely helpful when coming out with our guidances. And surprise, I've got one last quiz question for you. Ella is appointed to an IRB, and the chair designates her to conduct expedited reviews. Which of the following can Ella do? I'll give you a minute to review the answer choices, and please select the best one that applies. And they're coming in, the responses are coming in. This is your last chance to participate. No more quizzes, I promise. This is really it. And just to make sure that we have time for questions, I'm going to close it in 3, 2, and 1. And there you go. And good. Again, most of you got this correct. Ella can make the exempt determinations. So remember, the regulations don't say who can perform this task. So it can be an IRB administrator or it can be an IRB member. It's up to the institution to decide and have a policy in this. And as an IRB member, she's eligible to conduct limited IRB reviews. And she's been designated to conduct expedited reviews by the chair. So this is fantastic. Now, the last answer choice is a little tricky. We talked about this towards the beginning of the presentation. But an expedited reviewer can approve and refer to the full board for discussion, but only the full board is allowed to disapprove. So therefore, Ella can do everything but the last point. She's not allowed to disapprove research because expedited reviewers don't have that permission. They don't have that power under the regulations. So some closing thoughts. Please be sure to remember that the same criteria are required for approval through expedited or full board review. This is the 46111 and 46116 criteria. They apply to both full board and expedited review. When looking to use expedited review for initial review and approval, make sure that the research is 1, minimal risk, and 2, it fits within one of the expedited review categories. As we've seen, being minimal risk alone is not enough. Changes to research have the ability to alter the classification of a study. A change in identifiability of participants might make an exempt study now have to go through a limited IRB review, or perhaps even go through expedited review. Changes in risk can elevate a minimal risk study to greater than minimal risk. When reviewing amendments, and at the time of continuing review if applicable, make sure that these changes are considered in the proper context. Lastly, an institution is always free to add additional requirements for research. The regulations serve as the floor, the bare minimum, but institutions can always add to it as they see fit. Again, this was a very brief introduction, introduction to some very detailed topics. We have some guidance available on IRB written procedures, continuing review, reportable events, and please remember to review and comment on our draft limited IRB review guidance. As I mentioned earlier, we have some mini tutorials on the concepts of IRB membership, as well as on quorum and voting. And with that, thank you very much for joining me today. And I'll stop here so we have some time for questions. Thank you.